I wanted to talk to you about the three biggest differences between a will and a trust. It's the question we get asked the most, and it's something that anybody who's starting the estate planning journey needs to understand really well. Number one, a will does not help you to avoid probate. So what's probate? Probate is the court-supervised process of transferring your assets. In general, it's expensive, it's inefficient, it's public, it's long, and it's something that almost all of our clients would try to avoid. So creating a will does not help you to avoid that process. Rather, the will has to be submitted to the court, and the judge or the clerk will prove that it's valid, and then the entire process is managed and supervised by the court, in most states at least. So it's something that most of our clients would want to avoid and think that a will can help them avoid it, but in reality, a trust is a much better solution for avoiding probate than a will. Point number two, a will does not actually cover most of your assets. So as we said, a will has to go through probate. There are certain assets that avoid probate altogether, which is basically any asset that is jointly titled or that has a beneficiary already associated with it. So for most people, that's most of their assets. Think about a jointly owned home for a married couple, maybe a retirement account with a beneficiary designation, or a bank account or a life insurance policy, all of which typically have beneficiary designation options at least. And so if you have a beneficiary already identified, it's going to go to that person and it's not going to be governed by your will. So that may or may not be a good result. It'll be an outright distribution to the person, but the terms of your will won't have any impact over those assets. So a person who thinks that they've set up a will to achieve their distribution goals often doesn't recognize that the will doesn't cover much, at least on the first spouse's death. So contrast that to a trust in which you actually transfer your assets to the trust while you're alive, or you name the trust as a beneficiary, and then inside of the trust you can dictate and stipulate who gets what, how old the beneficiaries need to be, or you can set goals around how their wealth can be managed. You can include special needs provisions. So it's a very flexible tool to account for wealth distribution in the event of your passing. Point number three, and the last point, is that a will doesn't actually go into effect until you pass away. So it's a document you write and you sign, generally in front of two witnesses and often in front of a notary, but it doesn't do anything until you pass away. Contrast that to a trust, which is something that you sign and set up in your lifetime, and you actually will transfer your assets into that trust. So the benefit of doing so is that it becomes effective immediately. So in the event you're incapacitated, God forbid there's an accident, there's an illness, and you're no longer able to manage your assets, but you're still alive, the will doesn't do anything. And a person would theoretically need to go to court to get access for your assets if they don't have a power of attorney. But the trustee of your trust can step right into your shoes and manage your assets without having any court process. So it's a much better tool for managing incapacity than a will. So those are the three biggest differences. A will doesn't help you to avoid probate, it doesn't cover all your assets, and it doesn't account for incapacity, all three of which are done better inside of a will. So we'll talk more about what exactly a trust is and how the mechanics of a trust function in our next video. If you have any questions, reach out to us. We'd be happy to assist.